today. And this is with regard to a tender matter, writ appeal, my lord. And the matter may be fixed for tomorrow, my lord. There is some urgency. Listing of my writ appeal, my lord. It was fixed for today. An order was passed on 30th.
Okay.
Some document was ought to be produced. So, my lord, obliged, my lord.
May I please, Honor, I beg to mention for listing of it was last listed on my lord Wednesday or Friday. There was no bench. Again listed on Monday, my lord. There is an urgency. Maybe listed on tomorrow, my lord.
It's a new matter.
New matter, my lord.
What about Friday?
Friday, my lord. There was no bench in last Friday, my
No,
lord.
no, this Friday.
This Friday I will not be available. Let's try tomorrow, if possible, my lord.
Okay.
Must oblige, my lord.
Lordship, may I plead? In today's list, item number 15, there is paper book 3 shown, but Lordship, I have not received the paper book. So Lordship may direct that paper book may be given to us and may the matter be come after 1 week. Item number
Paper
15.
book has not been given to you.
Yes,
You just wait. We'll see.
Please, your
You
lordship.
wait.
I beg to mention item number 11. I'll pass over the matter for the day.
Why?
My senior is unwell.
Your senior is unwell.
Yes, my lord.
Yeah, you wait.
Make the lordship mention for listing IA on 21
Where? Division bench.
prison bench
On
for
20.
21
With regard to what?
for IA for bail.
For bail.
Hello.
Please, your lordship, I beg to mention for listing of repetition on 17th this month, Friday.
Division bench.
Division bench.
Division bench matter.
Yes, it's a foreigners matter.
It's
It's a foreigners matter.
foreigners tribunal before this court. I think Justice
No, I
Vijay
think,
Barua.
yes, code number 8.
I've mentioned in 8, but it was wrongly mentioned, so I was told to mention in this court.
Foreigners tribunal matter.
Yeah. Number 8.
I think it's court
I
number 8.
mentioned, but this is wrong. Yeah.
And the court there said that you come here.
Yeah.
The division
They-
bench.
No,
said-
there, it's there on 15, there, code number 8 is there for FT.
Last week I mentioned it.
No, today is the,
Okay.
just make a mention.
You mentioned it there. Vikas.
Okay, I'm like,
May I please your lordship? Lordship, we have filed two IA in relation to item number 3.
33.
No, 3.
Three.
3. Lordship, we are supposed to, we have already got higher marks than the candidates who are involved in this case. So regarding this, we have filed two IA recently. So Lordship, kindly allow us to take the IA along with this. please.
Lordship, we have been served a copy last evening, Lordship, later in the day. And we need time to respond and examine the matter, Lordships. I beg that it may be taken up on the
Just about
first.
the item 1, no? You just
Yes.
wait. Let it fall. Your item 1, just wait.
Yeah, in relation to Lordship, item 3.
Just that.
You're in item 3. Item
One.
3 is part of item 1 only. Part of it.
May I please, your lordship? Lordship, I beg to mention item 9 of today's daily list.
Yes.
Lordship, can the matter be adjourned for the day fixed after 2 weeks?
Just a minute. Just a wait. Just wait a little bit.
May it please your lordship, with regard to the yesterday's matter, I have given few judgments
Okay.
on prosecutrix, how her statement has to be dealt with. One judgment on that. Second judgment on that, the history written by the doctor. But then I couldn't get any Supreme Court judgment. High Court I got, division bench, and of Gujarat, no, Gujarat and Uttarakhand.
To what effect?
Gujarat High Court said that those statements are like the first statement of the victim. And that needs to be contradicted or corroborated, has to be placed before the victim while she was examined.
Okay.
This is what Gujarat High Court said. But Uttara High Court, what happened while dealing with the entire case, they dealt with that history and then they had acquitted the accused. This is what the Uttarakhand did. So other judgments I couldn't find. And the fourth one I've given on dying declaration, how it has to be dealt with. Paragraph I've given.
No, dying declaration, I think it's.
It is more or less
more or
settled.
less. Unless the deceased person gives 2-3 dying declarations.
Multiple,
Then of course, we'll have to see whether consistency is there.
Otherwise, it's on basic few, one paragraph, number of points it was given. 4 judgments it's with you. Lordship, obliged.
Lordship, can it be taken up sometime? The counsel for the bank is not there.
I'm here.
Yes.
Yes, so
Lordship, here in this case, the only requirement is that this there is a notification issued by the bank with regard to the property to be auctioned. And that particular notification has been put to challenge before the DRT, Honorable DRT. Now that Honorable DRT has passed an order.
where is the challenge? You have agreed to it, in fact. You have
Lordship.
also given the 10%.
Yes, 10% and
Already.
20% I have also given, Lordship.
Then,
Lordship,
what remains?
because the 30%, because the direction was for 50%,
Yes.
10%, 20%, the rest amount of 20%. So
Where
I am
have you
having
said
some
that-
personal
Where have you
difficulty.
said that you have given the 20%?
Lordship.
Where have you said that that you have given the 20%?
No, the problem is that, Lordship, on the last occasion, I made a mention on Friday. Since the matter was not taken up, that's why I've arranged the amount and I have
Then
deposited
you
the.
mentioned it again yesterday, by yesterday.
Exactly, Lordship. The rest amount of 20% I have to deposit within a period
And,
of 2
and
weeks.
there is no challenge to the order.
Lordship.
There is no challenge.
Because
to the
that order has not been, I have not been able to collect that order. This order is not uploaded. Because the order, verbally that order was given that I am not
Whatever
allowing.
it is,
Yes.
the order made
Yes.
earlier on 27/1
Yes.
has not been put to challenge.
No, I'm not challenging that order, Lordship. Only thing is that if your Lordship kindly see the last annexure, this is the page number 29.
Yes.
Page number 29, Lordship, an application was filed for modification of this order.
Page number 29. is the
Page number
schedule.
29 is for modification of the order dated 27/12/2022.
So let it be decided. So what
No,
is the
Lordship.
decision there?
Lordship, what happened? I have moved this application and it was numbered. This IA was numbered before the concerned DRT. But the thing is that at the time of submitting the application before the concerned DRT, that was not taken into account. Stated that you have to comply with the order dated.
Yes.
I made a specific statement in my writ petition also, Lordship, with regard to that. I'm just praying for some time because I will pay the entire amount, even the 20%, the rest amount to 20%. I am praying for some equitable relief, Lordship, here in this case. By the end of this next month, Lordship, I will clear the entire amount, Lordship. And that is the reason why, Lordship, that I filed this application before the concerned DRT. That was not taken into account, Lordship.
We do not know what order has been passed.
Because the order has not been uploaded, Lordship, because the.
You were there when you were moving.
Yes,
an
Lordship, I made a
application.
specific statement in my petition, Lordship. It's a pleaded fact, Lordship. Although the order is not there, since I could not get the order because it was not uploaded in the system, I made a specific statement with regard to that. I moved the application and that was not taken into account.
Yes, what is your subject?
My lord, they have an alternative remedy to go to the debt recovery appellate tribunal. Yes, my lord. Section 18 is there.
Give us.
Surface Act 2002.
Section?
Section 18, my lord. May I read one?
This is.
Yes, ma'am. Appeal to appellate tribunal. Any order, any person aggrieved by any order made by the debt recovery tribunal under section 17 may prefer an appeal, along with such fees as may be prescribed to the appellate tribunal within 30 days from the date of receipt of the order of the debt recovery tribunal. My lord, there is alternative remedy available.
Lordship,
Let me go there.
Lordship, may I submit one
You
thing?
had all the time in the world to go
Lordship,
there.
may I submit one thing? Here in this case, I made a specific statement with regard to fair. That impugn order, if there is an impugn order, that I can challenge before as per the provision of section 18. But since it was not considered, because at the very threshold, when I pressed this application, that was not considered. No order has been passed with regard to that. That has not been considered because 27(1) there is a specific direction of the Honorable Tribunal.
No order has been passed.
Exactly, Your Honor, and I have made a specific statement with regard to that in my petition also. And that is the reason why this applicability of section 18 is not, cannot be taken into account in this case. Yes. Yeah, in
Right
this
now
case,
you said no order has been passed, but when you look at para 11 of your affidavit, it says that by order dated 8/2/2023 has been rejected.
Lordship, verbally it was rejected, Lordship, but no order has been passed. Because verbally it was rejected, because no
Verbally
order,
the-
I have tried to get the,
verbally-
Lordship, I can
No.
file additional affidavit with regard to that. Verbally it was rejected because I tried to get the certified copy. There is no certified copy available with regard to that. Even in the website, the order has not been uploaded. So under compelling circumstances, I have to approach this honorable court. I am just praying for some equitable relief. I will clear the rest amount of 20%.
What was the, now, first of all,
Yes, Lordship.
your application, what was the number given to your application?
Yes, the number is IA number 104 and 105.
104, 105. Where have you stated that?
Lordship, page number 10. Page number 10,
Yes,
starting from paragraph 11.
yes,
Lordship, kindly see the fourth line.
yes.
If I'm taking the right file. This starting from page number 9. This for which e-auction has been initiated is the only residential property of the petitioner where his family is residing, and the petitioner, without there being any other option available, had approached the learned debt recovery tribunal Guwahati filing one application being IA number 107 of 2022, thereby praying for some respect to his genuine inconvenience, and there is always bona fide intention on the part of the petitioner to clear up the
Yes,
outstanding.
just tell me one thing. Has any order been issued in this?
My lord, on that day, the petition was actually rejected.
Was rejected?
Rejected by the tribunal. I'm not aware whether
Is
that.
there any order? He says that no order has been
No,
uploaded.
definitely there should be some order.
There'll be an order. I don't think there cannot be.
There should be some order.
You just find out. We'll take it up after some time. If there's any order uploaded or whatever. Okay. You show
Or
me that.
maybe since there is no access, can be taken on another team. In the meantime, I can search in the DRT because I have to go to the DRT to search the order.
It's not uploaded usually.
I'm not
uploaded.
aware, madam.
Huh?
I'm not aware whether it is uploaded or not.
No, it is not.
No, if whether you can just find out by
Exactly.
phone also whether it
After
is.
some time,
We'll take it up after some time.
yes, after some-
Okay. after some time.
Similar matter.
Huh?
Similar matter, madam.
Yes,
Same party. sir.
Just obtain that instruction
Yes,
whether
yeah.
order has been issued or not. That's all. He says that no order, only verbal order. That is his case.
Yes.
But if there is a written order, then
Yes, madam.
yes.
Lordship, please, Lordship, we have filed to IA regarding the matters. So Lordship, kindly allow us to take the matter.
Who are you? Are you party here?
No, Lordship, we are actually a stranger because we are supposed to, we have already got a higher marks than the person involved in this case. So we have filed the IA. Lordship, kindly allow us to hear the matter when the matter take together.
What to do, Mr.
It will be actually what they are saying. They are Mizo ST, they have got a higher marks. But there are some orders which has been passed by this court. 3 seats should be kept vacant. In fact, they should make, we have written the government of India, but they should make Union of India as a party also. They have not made a party of India.
You make them a party.
Union of India should be made a party
You make
by
Union
my
of India
learned
party.
friend, not by, he is now, he should intervening.
You have asked for impleadment.
Yeah, implement. But main writ petitioner, I think my learned friend is appearing. And what has happened, there was an interim order passed by this court. 3 seats should be kept vacant. And 3 seats should be given to the petitioner who is a non-Mizo ST. Now that the government has conveyed the order passed by this court, then it was sent to the ZMC. ZMC has written back to the government saying that as the seat, because last date was December 2022 admission, so they have to inform the government of India. Approval has to be there. So I think they didn't make the government of India as a party. We have written to the government of India, twice we have written to the government of India.
Initially, the need did not arise, Lordships. May I take instructions in this matter and file
Okay. Miss
S. Chakravarti,
S. Chakravarti, learned counsel for the
writ petition.
petitioners. Seeks how much time?
Lordship may come up on the first or second as convenient. Means,
Third.
after third,
After
after
third.
third, Lordship, my
After
senior is
third.
not available.
When is that?
Third of-
You give me a date. Is a date required?
Professor,
They
yes,
give me a date.
Ninth is okay.
ninth,
Is that the matter?
9th of March.
Maybe adjourned till 9/3/2023. As she needs instructions with regard to whether the Union of India should be included in this writ petition. Then Mr. D. Das, the learned AG Mizoram. Anything to say? Submits
Yes.
that the government of Mizoram
Yes.
has written letters twice
Yes.
to the Union of India
Yes.
with regard to the
Seeking approval.
the seeking approval for filling up the 3 posts by the petitioners.
Yes.
3 posts of MBBS.
Yes.
By the petitioners. So, however,
Pursuant to the order dated 6/1/2023.
pursuant to the order dated 6/1/2023. Full stop. However, no communication has been forthcoming from the Union of India. Full stop. Next para. Anything, Mr. Yukenar?
No, not sure. I'm for the private.
Okay.
Nothing.
Mr. Yukenar appears for the private respondent. Anyone else?
That's okay. They are assisting.
Okay, then what about you?
Lordship, Lordship, kindly take the matter along with this matter so that it will be hard to get.
What is the matter?
Lordship,
What is the case number? IA number?
IA number is Lordship 1668/2023.
You file that, let it be listed anytime. How does that have anything to do with it?
It can be tagged, my lord, because their percentage is higher.
Okay, on the prayer of Mr.
K. Deka.
Yeah?
K. Deka.
K. Deka, learned counsel who submits that the applicant that IA number
1668/2023.
Oh, serious.
168.
We do not know if it is under objection also.
It will finally be, it will come.
It will
No,
be
it will
registered.
come, it will come. They will approve the
No,
register. It will come.
You see, you have it listed. You can ask for a separate listing for this. List the matter on. When?
9th of March. April.
Lordship may give the memo.
Yes. When for when?
On 9th.
Oh, 9th.
9th. April.
Yes.
obliged.
May I please, your lordship?
Yes.
The appeal is against the judgment and order dated 18/6/2003. Your lordship.
Heard, Miss.
It is for admission for the first time.
This is for admission.
Yes, yes. Heard, Miss R. Goswami,
Yes.
legal aid counsel.
IAS, no?
Yes.
Or suspension.
For
Submits that the judgment dated 18/6/20, no, 2003, passed by the Sessions Court Nalbari in Sessions case number 2 of 2003, by which the appellant has been convicted under
section
under section 302 or what?
364, 302,
364/34 IPC,
302,
302/34 IPC,
and
and 201/34
Yes.
IPC should be set aside. Admit the appeal, call for the LCR. Issue notice to the respondents. No, to the respondent.
Comment.
The respondent.
No,
To the, this is to the respondent, Miss S. Jahan, additional PP accept notice on behalf of the state.
Respond number 2, Naika.
let's see, bail petition is there.
List the matter.
Suspension, I'll
list-
file my objection.
List the matter after receipt of the LCR. Then in the IA, you're right. This is an application for suspension of the sentence dated 18/6/2003 and for granting bail to the petitioners. Ms. L. Jahan, additional PP, seeks 2 weeks time to file written objection. This is the matter after 2 weeks.
Well, this is a statutory appeal against the judgment passed by the learned special judge convicting the petitioner under section 366(419).
Okay, heard Mr. S. Biswas, legal aid counsel, who submits that the judgment dated 4/11/2022 passed by the special judge POCSO, Kokrajar, in case number special 29/2020, by which the appellant has been convicted under
Section 366.
366/419/370(a)/372 IPC, read with section 6/17 POCSO Act and section 5 of the Immoral Traffic Prevention Act should be set aside. Admit the appeal, call for same thing, huh?
In fact, a POCSO matter, but notice to informant again is Lordship has considered the judgment and
I don't know, that is, you see, that it is still to be decided. Now, whether notice should go to informant, you see, there is, I don't know. Now, supposing a bail application is submitted by somebody. If notice is to go to the respondent, to the informant, the
There will
very
be
purpose
delay.
of bail would, you see, bail has to be considered and disposed of at the earliest.
Yes, yes.
Now, again, and you need at least 3 or 4 weeks time to issue. Then, and to say that the deemed service 1 month has to pass. So, I mean, there are a lot of nuances to this.
There will be delay.
There will be delay. So, I
And
do not
deeming
know.
is not possible here because deeming is only in case of central or state made law. Here there is a notification and Guwahati High Court rules. So section 27 of general clauses will also not come. And Lordship has considered the judgment before the notification was issued, before Lordship has shown me that.
That will have to be now decided by the
yes.
full bench, I think, whether, you know, the judgment. So, so right now, well, what do you? Then this is the matter after receipt of the LCR.
No.
Oh, like that.
There is no bail application here, no? No bail.
There's no.
Lordship is an application preferred by the state of Assam against order of acquittal, judgment order of acquittal. There's delay of 2604 days in preferring the appeal, your lordship.
That is more than 7 years delay.
Lordship, but it's a state appeal, your lordship. Your lordship will kindly consider the cases that your lordship, a minor girl was raped by her employer, 13 years old girl, your lordship. And there's injury on her private parts, my lord. All those factors have been not taken into consideration by the learned court below, my lord. So lordship, I think we have a good case in appeal, my lord. Your lordship will kindly overlook and those aspects of the matter of delay, your lordship. And your lordship, since in the merit we have a case, your lordship may be pleased to allow us to allow the application.
What is the reason for the delay?
Reason for your lordship is some pages of the judgments were not there when the copies were served on us. Your lordship is aware of the government offices, how they function, your lordship. Some pages are missing, then we have to apply for the certified copy for the whole lordship, the branch. Then we lordship taken permission from the LR also, some communication. So there's delay, your lordship.
7 years delay.
7 years delay is there.
Yes. That's all.
I don't find any other reason in my petition, my lord. And one more judgment I want to cite on the Supreme Court judgment I can rely on. Let him.
Well, first of all, Lordship has rightly noted 7.5 years, and by now more than 12 years has gone by.
No, not 7 years, not 7.5 years.
Less.
I think 7 years, less than a month, I think.
29/9/2010. 29/9/2010 is the judgment. And the law on limitation is, well, everyday delay has to be explained. Now here your lordship will find the entire blame has been given to the public prosecutor who was conducting the case at Moriga. Now question is whether public prosecutor is responsible for giving them information or asking them to prefer an appeal. The police manual is provisions are quite clear. It is the SP who in consultation with the district magistrate may request for preferring an appeal. The person advocate, he himself has not been made party here. And secondly, the responsibility also is on the superintendent of police and the district magistrate under the police manual. The public prosecutor, he doesn't have, once the matter concludes, he doesn't have any say in the matter. So therefore, this is the explanation that sought to be given is absolutely non-existent ground. And so far as the merit that has been submitted, it is the categorical finding of the court in the judgment itself, that the version of the victim is not consistent. The reporting is also much after delay. Then in between she visited someone else's place, brother-in-law, etc. So I am not on the merit, but here itself, 2017, this has been said that public prosecutor has given the information. 2010 judgment, 7.5 years, the entire blame has been given to the public prosecutor. And that in the Postmaster General, the case in 2012.
Give us the judgment.
Yes,
we don't have that computer brain like
Lordship,
some of you.
then I'll also place some certain judgments. Can it be taken up tomorrow? Because a copy of the objection has been served on me just minutes back.
A copy was given to the office long back, but then she requested me for
one thing. When was the judgment and order announced?
It was 29/9/2010.
29/9/2010.
Yes.
When was the copy of the judgment given to the government?
Lordship.
2017.
Huh?
2017.
Yes.
December
Lordship,
2017.
paragraph 3 of our this one.
Paragraph 3.
3 of our appeal. IA 183.
No, that the one with the missing pages. When was it? When did you all get to know of this judge, of this case, or the final decision made by the court?
Lordship, that paragraph 3, our office, that a request for preferring appeal against the state judgment.
Prior to, you see, prior to
Yes,
preferring
prior
an
to
appeal,
that, it's
you will
not
have a
there.
copy of the judgment. You cannot make a decision with regard to preferring an appeal or not without
on
looking
own.
at the judgment. So when did you receive that judgment prior to deciding whether to file an appeal?
That's not there in a
Well-
petition. That was, this was preferred by one of our colleague, your lordship,
Yes,
long time
but
back.
then
Lordship, I'll satisfy because
no,
the
there's
state
nothing to
appeal, your
satisfy,
lordship.
madam. You cannot go beyond your pleadings. You have said here that the request for preferring an appeal against the judgment was received by so and so from the office of the LR in the month of December 2017. Now, what happened between 2010
10
and
and 17,
2017
whether any
is
document,
completely silent.
lordship, that aspect, your lordship, if any document is available in our office, because that is not prepared by me, my lord. This lordship
it's not the-
kindly,
it's not the
because the
issue of-
lordship will kindly consider, lordship, it's a 376(1) matter.
Maybe you are the
My
one-
lord, so
you are the
lordship, and minor girl, your lordship will kindly look into, your lordship, she was raped, your lordship, allegation. She was an employee of that
You
officer.
had-
He's an officer of a police department. He wasn't, she was in the quarter, my lord. And inconsistency here and there might be, my lord, because she's a 13-year-old girl. Lordship will kindly consider the matter may be taken up day after tomorrow. Today is a Tuesday, either on Thursday or on Friday. Today is Wednesday. On Friday, your lordship, I'll try to satisfy, I'll try to find out in our office whether any document is available in that regard.
How can you go beyond your pleadings? That's
Lordship,
that's
a
the law of
liberal
property.
approach should be taken in these matters, your lordship.
Liberal
Supreme
approach,
Court
no
has
doubt.
also
But
said, my lord.
when there's a blanket, when there's a blank space
Yes,
for 7 years,
yes.
without an attempt to explain that period, how can we decide?
Every day's delay need not be.
No, every day delay we're not
Yes,
asking.
yes.
But you're asking for turning a blind eye, Nelson's eye to 7 years.
Lordship on Friday. Friday, I'll try to satisfy if something is there. Lordship on Friday, no?
No.
Lordship, kindly on Friday, because your lordship, that aspect, that records are also not available to me.
No need of
When it
record.
was lordship.
Madam.
Lordship, today it may not be, maybe tomorrow, my lord. Maybe tomorrow, because the lordship state appeal, I have also some pressure, my lord.
You may.
Lordship, I'll just try to find out if some documents are available. When it was lordship applied for a certificate copy, when it is available, then delay would be counted, my lord. Sometimes your lordship, in open court, the judgments are delivered and certificate copies, there is a delay in issuing the certificate copy. Lordship, that aspect I'll look into.
Madam, those aspects are not here in the affidavit. You
Lordship,
cannot,
lordship, tomorrow I'll
you
try to
cannot
find
go
out.
beyond your pleadings.
I'll try to find
No,
out, your
no.
lordship. Tomorrow, your lordship.
No.
Lordship, kindly may be taken up tomorrow. It's a lordship will kindly tomorrow, my lord. Tomorrow it may be taken.
Why?
Up.
Tomorrow again, we
as a
have,
first item, it may be taken. Up.
tomorrow again we have got to read some other files.
Lordship, lordship will kindly take up tomorrow.
Too
my lord.
extraordinary. It is too many 7 years delay. You have not even tried to explain it at all. September 2010 order issued.
Yes.
Impugned order issued.
Yes.
In November 2017, or not November, December 2017, after 7 years, you decide to file an appeal. No explanation, no attempt to explain those 7 years.
So, your lordship, tomorrow, one day, nothing will happen because they are also taking time.
No,
lordship.
We'll decide solely as per your application.
Yes, your lordship, tomorrow, my lord.
today.
Not today. Can it be taken up tomorrow, my lord?
Why?
Tomorrow, your lordship, I'll try to satisfy your lordship.
How will you satisfy?
I'll try to satisfy. If some communication is there, some communication, if records will reveal that those, because of those communications delay, for the reasons unknown, it was not described in the appeal memo or in the leave application. Tomorrow, your lordship. Yes.
Nothing.
Lordship, tomorrow is first item, no?
Tomorrow, okay, right.
Only one
Tomorrow
thing,
or
my lord.
maybe Friday.
On Friday.
May I press one thing, my lord? Under the my lord, police manual, part 4.
Yes.
In case of acquittal, where there has been a grave miscarriage of justice and the superintendent of police thinks that an appeal is necessary and is likely to be successful, he should with least possible delay, send the district magistrate a full note on the case so as to enable that officer to move the local government to appeal to the High Court under section 417 CRPC, it is the old code. It should be noted that as a matter of practice, the local government declines to appeal against the order of acquittal unless moved to do so within a period less than 3 months from the date of the order, hence need of prompt action.
So Lordship,
Specific
in
provision,
these
my lord, it
cases,
is
my
not the
lord,
public
public
prosecutor.
prosecutors we are the representative of the police department or the state of Assam in criminal matters. So entire Lordship responsibility is based, unless they issue a note, my lord, give a note to us to prefer an appeal or LR sends us some communication, we don't file. They send, lower court send to us or to LR, then LR send communication to us.
Anyway, right.
On Friday.
On the prayer of Ms. Dibuyan. Then senior counsel.
Assisted by M. Chakravarti.
Assisted by Ms.
M. Chakravarti.
List the matter on Friday.
17th. Obliged.
Last occasion, there's an order allowed to send notice to the victim, madam.
So paper book has been received.
Yes, madam. The last order, madam, is to send a notice to the victim, madam.
Huh?
2/1/2023, madam. There's an order to send notice to the victim.
So there is no return of AD cards or answer notice. Now what to do? And where you see, now we got to await service report or what?
Since the Lordship, this is a judicial order.
Huh?
Lordship will try to serve through the concerned police station, since there is already an order, judicial order. Put to police station.
Sonari police station.
Huh?
Sonari police station.
So what do we say in the order?
Lordship, registry may be directed or we may be directed.
Okay. Okay, right.
Registry may be directed.
The counsels for the parties are present and submit that they have been furnished a copy of the paper book. With regard to the notice sent to the respondent number 2 on 5/1/2023, office note dated 8/2/2023 states that there is no return of AD card nor unserved notice from the respondent number 2. Notice be again issued to the respondent number 2, which should be served by the
either by the registry or through us. We'll also take steps, my lord. Through the registry.
By the registry through the
officer in charge.
OC.
Sonari police station.
PS. This is the matter after.
Sonari Sipsaga, no? 3 weeks after 3 weeks.
May it please go.
Yes.
But again, I presume the informant has to be informed, and she has been informed, and somebody is representing her, my lord.
Okay.
But
today, Lordship.
Anyway, that is we can do the we can at least dispose of the IA.
Lordship.
IA, Lordship.
IA.
IA.
Cancellation. suspension of sentence.
Okay.
I think paper book has been received
Yes,
by
my lord. Paper book has been
paper book has been received. Right, the counsel for the parties submit that they have been furnished copies of the paper book. Accordingly, leave this matter for hearing in usual course. Then in the let's dispose of something. Yes, what is your case?
One of the cases that I have been accused of violating a girl child.
Accused of violating a
girl child.
Yes.
And she was pregnant and she gave birth to a child.
How old was she?
At the time of lodging of the Ejahar, she was about 13 years old.
And this is your child?
No. That has to be proven. That my sole case rests on the fact that DNA test was not done, even though both were taken to the hospital for DNA test. And the doctor has categorically stated that without the DNA test, parenthood cannot be decided.
So has the DNA test been undertaken?
My lord, yes, I'll take that to your lordship. I'll take your lordship to the paper book. Your lordship will kindly take the paper book.
Yes.
In the IA, lord, there is a paper book.
Yes.
Your lordship will go to page 20, my lord.
Yes.
Just a minute. Sorry, 70. 17.
Yes.
May I read, my lord?
Yeah.
Deposition. A so and so, so and so, so and so. Yes, my name is Dr. So and so. So and so, so and so. On so and so, I was working as PG on duty. I'll just read I examined so and so, female, the victim. Then your lordship will skip that. So and so, so and so. There's a detail of her physical attributes. There's a detail of her physical attributes. Page 19, column 5, para 5. Rather. She is referred to so and so GMCH for DNA test for collection of necessary sample as the victim is pregnant at the time of examination. Cross. The history, so and so, second line, my lord. I did not receive any DNA test report. Without the DNA report, it cannot be ascertained whether the victim has been pregnated by the.
That is a different aspect. That is a medical officer's view. That is different.
And that is also, my lord, perhaps.
So that will see, but then the other aspect of you having sexual intercourse with her.
Yes, but this is the allegation.
No, do you deny that?
We deny that.
You deny that. So the DNA report, where is the DNA report anyway?
It was not conducted at all. Huh? It was not conducted at all. It's written in para 5 itself is written, Lord. Your lordship will kindly read that again.
Yeah, who is for the informant?
Lordship, yes, somebody is
legal
being
aid
shown.
counsel has been appointed, Lord. Perhaps she is not aware of it.
Probably you won't find that.
I'm sorry, I can't assist her because I have only one set of the document.
Anyway, this IATO will dispose of. That aspect we'll look into later on.
Yes.
Because whether child is yours or not, the very fact that the child has said that you had intercourse with her is enough. It's the
And
child
his
may be
previous
somebody
history, if I'm not wrong, I don't have the records today available with me.
May I make one more submission, my lord?
Yes,
Your lordship will kindly the child, whether it is assumed when a child says that she has been violated by a person, it is assumed.
Yes.
And the POCSO is reverse burden, Lord.
Yes.
I have
Yes.
to prove it.
Yes.
POCSO is reverse burden.
Correct.
Now, even when I am convicted, I am charged against in POCSO, I'm as good as the convict, my lord.
Correct.
Now, what my knowledge says that there are two aspects I would like to point out, my lord. Page 11 of the IA, my lord.
Page 11, yes.
PW2.
Page 11 of the IA?
I mean paper book, my lord. Paper book in the IA.
Yes, page 11.
PW2. She is so and so neighbor, my lord. Okay. My lord, your lordship will kindly turn to page 12.
Yes.
Second line, the girl is a bit less intelligent and has not explained anything why she kept these things concealed for a long time. Now again, this is one.
It happens, it happens. I know of a neighbor, a few houses away, who gave birth, and the parents became aware that she had been pregnant for
Yes,
those
yes.
9 months only after she gave birth.
Yes.
That girl was a fat girl also. So it happens.
Then again, my lord,
The
please-
darling of the family suddenly gave birth to.
we understand, my lord. My lord, my job is to represent the.
No, I'm just telling you
I understand.
that
my lord. We
these
understand.
things sometimes happen that
These are very
they
traumatic
they
things.
don't speak about it.
These are very
It could
traumatic
happen.
things. These are very traumatic things. I understand, my lord. But I have a job to do, my lord. I have to
Yes,
play.
yes. No, it's okay.
Huh?
I'm just saying that it happens.
I understand, my lord. I appreciate that. Obliged, my lord. In fact. Page 13, my lord. Page 13. PW3. I know the informant, I know the accused.
Page 13.
Yes, my lord.
Yes.
Yeah. Now she is a employee of a school. Apparently in the same school where this girl was studying. Cross. Next page, my lord.
Yeah.
The girl was mentally retarded and not at all intelligent to explain the happenings. And lastly, no eyewitness. That's all.
POCSO
where
letter,
are you reading?
how
Where
could
are you
there be
reading?
eyewitnesses, my lord?
I mean, page 14, my lord, cross.
Cross.
Last, third line, my lord, the girl.
Mentally retarded. Okay.
And one last thing, if your lordship allows me, we have all the schemes for victim, my lord, but the accused are, I mean, especially where the reverse burden is concerned, my lord, accused are left high and dry. With all due respect and humanity, I will submit, my lord. That is very difficult for the accused to prove the case. The entire burden is shifted on the accused.
What to do?
Well, I'm just placing the facts. I'm leaving it for the consideration of the court. Your lordship.
Okay, right. Third, Mr.
D. Bhattacharya.
D. Bhattacharya, learned counsel for the appellant, who submits that the impugned sentence, who submits that the applicant was convicted under was convicted by judgment dated 12/11/2018.
My lord, I'm sorry I interrupt, my lord. In the IA, I mean, in the paperwork for the IA, a wrong judgment has been annexed. My lord. Your lordship may not refer to that.
Okay.
Your lordship may refer to the judgment in the criminal appeal. My lord. This has been done by the raised, my lord. Your lordship will kindly refer to the judgment in the criminal appeal.
Let us see. Judgment in the criminal appeal.
Yeah, I mean, the paperwork in the criminal appeal.
Paperbook in the criminal appeal made by you.
No, raised.
Actually, there is. I don't have any paperbook in the criminal appeal. I mean, this paperbook I've got. Yes, this paperbook.
That is, your lordship will see whether it's written
This
IA
is criminal appeal.
Is it
Criminal
written,
appeal.
no, is it written only criminal appeal or IA criminal appeal?
No, written only criminal.
Yeah, your lordship will refer to that. Page 26.
So this is judgment dated 24/4/2019.
Lordship.
Okay.
POCSO case number 13 of 2016.
By the passing judgment dated 24/4/2019, passed by the special judge Kamrup in special sessions bracket POCSO bracket close case number 13/2016, by which the petitioner was convicted under section
Section 6
of the POCSO Act 2012. The applicant, by way of the present application, prays for suspension of the Where is the sentence order? Raised for suspension of the sentence by which he has been sentenced to undergo a rigorous imprisonment for 15 years and to pay a fine of rupees 20,000, in default, to suffer rigorous imprisonment for 10 months. The applicant's counsel submits that the evidence of the witnesses goes to show that the prosecutrix was mentally retarded. As such, the statement made by the prosecutrix against the appellant cannot be taken at its face value. He submits that the appellant did not commit any offense against the prosecutrix, which can be covered under the provisions of the POCSO Act 2000. He also submits that though a DNA test was apparently taken with respect to whether the child that was born from the prosecutrix was the appellant, the report of such DNA test has not been produced before the learned tribunal.
DNA test has not been done at all.
No DNA test was done. No DNA test was done.
No DNA.
Anyway, are you willing to undergo DNA test?
No, that is the only. But at this moment, whether the girl child will be prejudiced or not, there is that question.
No.
He used to prefer an application for that.
You see, that is one thing. We cannot direct that you should undergo a DNA test. We can only ask you if you want to undergo DNA test.
Well, perhaps.
So you can ask your client if you want to undergo DNA test.
I think I'll have to get
Lordship, one more aspect, he could not rebut the presumption. And this prosecutor was consistent in her statement. Lordship, but he is an habitual offender.
That's not on that, madam.
Yes, under POCSO Act, earlier convicted, my lord.
I know that. That is the. I'm just saying this. So you just obtain instructions with regard to whether he wants to undergo DNA test. Okay, and right. He accordingly submits that the sentence should be suspended and the appellant should be released on bail and the applicant should be released on bail. Ms. B. Buyan, the learned additional PP, on the other hand, submits that the applicant is a habitual offender. And that the evidence given by the prosecutrix was not shaken or controverted during the cross-examination.
My lord, I'm very sorry, I'm interjecting, my lord. Your lordship will kindly come to page 20. Accused was also taken for DNA test. Accused was also taken for page 20, my lord. Your lordship will kindly see that.
So now
at the relevant point of time,
if he was taken for DNA test,
yes.
So he undertook the DNA test or not?
That I do not have that information.
So if I
he has been taken. Your lordship will kindly read that.
So I'll have to correct that.
Your lordship will kindly read that first, then my prayer.
Page 20.
Page 20.
Yes.
PW6. Name is so and so. So and so. my lord, on oath, last 4 lines, my lord. Again, on 4/3/15, the victim was sent for medical examination as she was pregnant. The accused was also sent to GMCH for his DNA test. So, my lord, I do not have.
Which date?
This is on 4. I mean,
Yeah, but there is, he was sent, but whether DNA test was done, that is not.
that I have no instructions.
Yes, right. The addition PP does submit that the application should be rejected. On considering the submissions made by the council for parties, we find that the fact that a 13-year-old girl was impregnated and a child born out of an illegal act is a very serious matter. Leaving aside whether a DNA test was conducted or not, the statement of the prosecutrix having been to the effect that
Lordship, the reasons given there.
to the effect that the applicant was, the applicant had raped her. Is, to our view, sufficient to reject the present application, keeping in view the reverse burden of proof required under the POCSO Act 2012. Accordingly, we do not find any reason to suspend the sentence. The application is rejected.
Perhaps the DNA record may not be
Lordship,
required now.
yes, it's given in the case diary. Lordship, since the girl was pregnant, the DNA sample can be taken only after the delivery of if abortion is done. That reason is given. But later on, she was not sent.
Abortion was done?
No,
she gave
either
birth to a
or.
child.
Doctor has given an opinion. Either if the abortion is done or after delivery, that only blood samples for DNA can be taken out. Yes.
But the evidence,
No, you see, we can always record in the main appeal.
Lordship, you can.
Yes.
That whether you all can take instructions from your client, whether you want to do DNA test. If you're willing to do DNA test, we'll record it.
My lord, one thing may I make a submission, my lord. Since he accused was also sent for DNA test, they let them get the instruction whether that was done or
That is a
not.
different issue. You see, whether it was done with his consent or not, that is also another issue. Okay, so we'll have to see that. So if you want, we can record in the main thing, but then before that, you all obtain instructions whether you want to do DNA
Yeah,
test.
perhaps
DNA test
I
will
may
have
have
to
to
be
file
done
an
by, it have to be done by you, done by the victim and also the child. Then we will have to see whether X and Y chromosomes. and-
Lots of things, my lord.
My lord. There is an order, my lord, available in the.
This was signed. Date is also given 8/2.
8/2.
Right.
Lordship, may I submit one thing, Lordship?
Yes.
Lordship, although this order, yes, in that order, The thing is that it is, I could not get this order in the website, it is not available. The second point is that Lordship, even if they.
It is option from the website.
You said that was a verbal order.
Exactly,
It was not a written order.
Exactly, Lordship.
This order
Exactly.
has already shown that it was signed on 8/2. Now, we
8/2.
have got no reason to disbelieve this order.
Exactly, Lordship. I'm not saying it just to be disbelieved. What I'm submitting here, Lordship.
You have made a wrong submission, in fact. You are trying to mislead this court.
No, Lordship, what has happened in the website, I tried to get this order from the website. It was not reflected in the website because the judgment is, the portal is there, DRT portal is there. From there, we can download the order.
You can always, when you ask, you can always go to the DRT and ask for a copy. It doesn't have to be from the
And the
website.
next option is that, Lordship, this alternative remedy, in spite of having the alternative remedy, the read code can always take into account
No
the
doubt.
inconvenience.
If your submissions had been true the first time, then we maybe would have
Lordship,
considered.
because we have tried to get the order.
Heard Mr. S.P. Chaudhary, learned counsel for the petition, who submits that that a direction should be issued to the respondent bank not to take any coercive action against the land of the petitioner and to grant the petitioner some time to deposit the 20% total outstanding amount which had been directed to be made by the DRT party in its order dated 27/1/2023. Yes, sir. The issue at hand is with regard to non-payment of the loan amount taken by the petitioner. Yes, sir. In view of the non-payment of the loan amount, the SARFAESI Act was put into play and auction sale notice dated 20/12/22 was issued by the respondent bank. The petitioner appeared before the DRT challenging the actions taken by the respondent bank under the SARFAESI Act for selling off the property of the petitioner which had been mortgaged as security for the loan. Next paragraph. The learned DRT in its order dated 27/1/2023 allowed the respondent bank to conduct the sale of the property. However, the sale was not to be confirmed on the condition that the petitioner would deposit 50% of the outstanding dues with the bank. Out of the 50% outstanding dues to be paid to the bank, the petitioner was to deposit 10% as on 27/1/2023 and no, 2023, 20% within 2 weeks thereafter, and the remaining 20% within a further 2 weeks thereafter. The e-auction sale scheduled to be held on 27/1/2023 was allowed to go on, but the confirmation of sale was stayed subject to payment of the outstanding dues as stipulated in the order dated 27/1/2023 passed by the DRT. The petitioner's counsel submits that subsequent to the order dated 27/1/2023, the petitioner deposited 10% out of the 50% outstanding dues on 27/1/2023.
And subsequently also 20% deposited.
Subsequently, another 20% has been deposited on
10 to 2023 and 14 to 2023. On 2 dates.
That
On
I
2
have
dates.
to verify from the bench.
No, you have already verified. The total amount you have
Because,
verified.
Anyway,
Because
that is not
30% he has
in the- that is
verified.
not in
also.
that is not in the pleadings.
No,
Yes,
my learned friend has
Because-
verified the total amount. Total
no,
amount deposited by the
whatever.
petitioner. Is the 30%
That
of the total
that
amount.
on 20% on 10
to 23 and 14 to 23.
10 to 23
And 14 to 23.
So stop. However, the last 20% of the 50% outstanding amount to be last 20% out of the 50% to be paid has not been paid till. He seeks for further time. No, full stop. The learned counsel submits that an application had been made by the petitioner before the DRT by IA number 106/2023 trying to allow the petitioner to make payment of 20% of the total deposit, to make payment of the 20% of the 50% deposit to be made by another 2 weeks with effect from 10 to 2023. The petitioner's counsel submits that the DRT rejected the petitioner's IA number 106/2023 by a verbal order, and as such he could not submit, he could not annex any order of the DRT rejecting IA numbers 106/2023 in this petition. Next paragraph. Mr.
B. Sharma.
B. Sharma, the learned counsel appearing for Indian Bank from a Guwahati branch, submits that there is nothing in the pleadings to show that the petitioner had paid any amount after depositing 10% of the amount on
27/1/23.
27/1/2023. So he submits that he would need time to obtain instructions in this regard. And just cut that. Cut that. He also submits that the DRT had rejected the petitioner's IA number 106/2023, praying for modification of the order dated 27/1/2023 by way of a written order and not a verbal order. And in this regard, he has given a copy of the order dated 8/2/2023 issued by the DRT, passed by the DRT, rejecting IA number 106/2023. We have heard that he also submits that the petitioner would have to avail of the alternative remedy available against the order dated 27/1/2023 and 8/2/2023 in terms of section 18 of the Surface Act 2000. We have heard the learned causes for the parties. Though the petitioner's counsel had submitted that I number 106/2023 had been rejected by way of a verbal order and that no written order had been passed by the committee, we find that the said submission is wrong, in as much as the order dated 8/2/2023 passed by the DRT rejecting I number 106/2023 has been submitted to us. Section 18 of the Surface Act 2002 provides that any person aggrieved by any order made by the DRT under section 17 may prefer an appeal, along with such fee as may be prescribed to an appellate tribunal within 30 days from the date of receipt of the order of the DRT. In the present case, neither has the order dated 8/2/2023 been challenged, and in the present case, no challenge has been made to the order dated 8/2/2023 passed by the DRT. In that view of the matter, we are of the view that the petitioner would have to avail of the alternative remedy available, statutory alternative remedy available in terms of section 18 of the Surface Act 2000. The writ petitions accordingly discussed. The order dated 8/2/2023 passed in I number 106/2023 is made a part of the record and marked as annexure X. In the 16, instead of 106, you make it 107. Okay.
May please your Honor. But we got the paper book on Friday, but we may be given some time to argue on the point of bail matter, sir. I think it's still pending.
What is there to argue?
Yes, there are material, my lord. Kindly.
You see, bail, the bail is different. The main, this paper book is there. We'll dispose of the IA.
My lord,
we can have the.
my lord, give me short time for bail matter. I'll submit before your lordship. Let it come after 2 weeks, my lord, I will do. Bail matter 2 weeks.
Okay,
They have
right.
given objection also.
Right in the appeal. Mr. S.C. Biswas and Miss L. Jahan, additional PP submit. The paper book has furnished to them.
Yes.
So this is the matter for hearing.
In due course, in the meantime, bail member, I may be considered but next week, after 2 weeks.
This is the matter for hearing in due course.
I don't know. My lord, regarding IA, date may be fixed.
We can hear it now. So okay, this is the
No,
matter.
no, my lord. I got the paper book on Friday, my lord. That's why we need some time. I have to go to the evidence, my lord.
You have to go to evidence. So we'll dispose of entire thing together.
Together.
Same thing. Same thing. We'll dispose.
I'll mention it then. I'll come.
You want a date? We'll fix the date for hearing also. You want?
Not so hard. If there are, my lord, a life conviction, please. Whole life conviction.
Rape. And then, okay, yes, I know there are. That victim slept with in the same bed with the wife.
No.
That is the case.
Yes, that is. There is no medical evidence. Doctor said there is no sign of rape. there is allegation of termination of pregnancy. You
Aborted.
said that we have not collected any materials from the hospital, didn't get any materials from hospital regarding termination. So these two goes. Doctor said her age is
No,
16 years.
that is why I'm saying actually, I don't think the entire case will have to be decided. I don't think you're going to have much luck with the IA because you have to go into all the aspects. And the fact that it seems that then you might have a case also, I don't know, because she was apparently sleeping with the wife.
Wife have been convicted under 313.
Achha, wife also convicted.
Yes,
Oh.
but there is no medical evidence of termination.
I don't.
That I will bring to your lordship. Kindly bear with me. Well, after 2 weeks, I may be given the opportunity to hear the on the point of bail. IA.
Why not the entire case? Why only IA?
Then after 2 weeks, the entire case can be taken.
We'll take
there
the
is a-
entire thing after 2 weeks, the entire hearing on the main case.
Then I'll leave it to you.
List the matter for hearing, for admission hearing.
Then your lordship has already fixed for in due course.
It is in
I'll
August.
file a, if necessary, I'll file a petition for listing the order early hearing.
So the LCR has arrived or not?
LCR.
So paper book is required?
My lordship.
Huh?
Yes, your lordship. And service report in respect of respondent
No,
number
no,
2 is
no
waited.
service report. No edit.
Waited, your lordship.
You see, notice was issued on 20 January and today is 17th February. So we have to await service.
Yes.
report. Okay, right. As LCR has arrived, registry to prepare the paper book. Next para, office note dated 21/23 states that there is no return of AD card or unserved notice. No notice. No. Office note dated 20/01/23 states that notice has been issued to the respondent number 2 on 20/01/23. So, however, there is no return, there is no service report with regard to the notice issued to the respondent number 2. Await service report. List the matter after preparation of the paperwork.
My lord, I have filed one IA for bail, your lordship.
Lordship, I'll take some time to, for objection, my lord, to file objection. This is for the first time it has come.
Okay, but okay, in the IA, right, Mr. A. Raman, learn process for the application. Ms. B. Boyan, additional PP, seeks how much time?
2 weeks time.
2 weeks time to file written objection. This is the matter.
Nice.
Continue.
Master please.
Contact number. Contact number.
Yes.
Yes, your lordship. My senior is unwell. Kindly pass over the matter for
No,
the
that is okay. You see, the thing is that you are supposed to take steps for service of notice in the main appeal. You have not taken steps.
Take
So
steps.
only on IA steps taken. I think.
Oh, IA, he has taken steps, but
Yes.
main.
However,
appeal-
notice has been issued to the respondent number 2 as petitions for the main case for the co-joined.
Main case also you take.
So notice was issued, but then there is no service. Okay, right. Mr.
S. Afridi.
S. Afridi.
Yes.
Case for adjournment on the ground that Mr. M.U. Mahmood, learned counsel for the appellant, is unwell. As per office note, there is no, as per office note, no LCR has been received from the trial court. Registry to send a reminder for the same. Office note dated 30/1/2023 states that notice has been issued to the respondent number 2. However, there is no service report with regard to respondent number 2. This is the matter after a receipt of the LC.
12, your lordship, we will be filing our objection. 2 days time may be granted, but there is a issue as regards service, my lord. Officer says.
That is it.
Answered notice has been, no answered notice has been.
Report has come that the addressee was not found.
Okay.
The informant was not found.
Now what to do in this matter?
But we don't have any other alternate address of the informant. We took steps in the address which was available on record.
Okay, right. Miss S. Buyan, B.
B.
Buyan,
Buyan, lordship.
additional PP submits that written objection will be filed within 2
Within,
days.
by this week.
Within 2 days. As per office note, notice was issued to the respondent number 2 on 9/12/2022. However, unserved notice was received back with the observation that no such person was in the address. List the matter. What about the main appeal? LCR is there.
LCR is there, paper book is not.
The paper book is there.
Paper book be prepared.
Okay, in the I right list the matter in the next week.
After a week, your lordship.
List the matter after a week. Then in the main appeal, you write, as LCR has arrived, registry to prepare the paper book. List the matter after preparation of, no, don't say anything, just prepare the paper.
Deeply obliged, madam.
May I please, Lordship? Also, we have taken steps in appeal.
What is this case?
It is a conviction under section 6 of POCSO Act.
So out here, there is, so in the main, in the IA,
Lots of IA we have filed for a stay of sentence during pendency of the appeal.
why should we allow this? Okay, no case out here.
Our objection is also on record.
Yes, what is your case?
Lordship, the main grounds of the appeal I have set forth, it may be considered for the IA also. Lordship, the main, our main ground is that the material object 1, that is the birth certificate, age proof certificate produced by the on behalf of the victim. The contents of that particular material object has not been proved as per Evidence Act.
So your case is basically that she is 18 years, is it? 18 years and above?
They have stated in through their material object, that is birth certificate, that she is 14 years age at the time of.
In fact, not even 14, actually.
Yes.
As per the birth certificate, she's 13 years. But what about the doctor's
Yes,
evidence?
Doctor's evidence, Lordship.
Age would be 14 to
Doctor's
16.
14 to 16, that's what the
14 to
X-ray
16.
report.
May I please, Lordship, doctor's evidence is considered only when the other document is not submitted on behalf of the victim. It is stated in the Juvenile Justice Act.
Yes, yes.
Latest.
Correct. So according to you, what would be the age of the victim?
Lordship, now my humble submission is that if the material object, that is the school certificate of the victim, ought to have been proved, contents of the particular material object ought to have been proved by the headmaster, then it could have been that her actual birth, date of birth may not be below 18. This is my overall submission.
And how old are you?
I am at that point of time I was 26. And Lordship, one more point on my behalf that under section 164 statement of the victim, she also stated that there is a love relation between the
But the problem is the age, too young.
Yes,
to have,
Lordship.
you see, 14 years of age, 14
Yes,
years of
Lordship.
age, too young. And not only that, you made her pregnant.
It is correct, Lordship. Lordship, may I kindly read the particular section of juvenile justice
So
for a moment?
according to you, you were in love.
Yes, Lordship.
And you made her pregnant.
Lordship.
And you made her pregnant.
She being a minor.
Yes, Lordship. It is a fact, Lordship. It is fact. I do not deny it. But Lordship, may I kindly read the particular section of juvenile justice?
Yes.
The latest Act of 2015, 94, section 94.
Yes, there is no
Regarding
quarrel with
age.
the proposition of
Regarding age,
94.
Lordship. Only regarding age. In section 94, Juvenile Justice Act 2015, it is stated that presumption and determination of age, where it is obvious to the committee or board based on the appearance of the person brought before it under any of the provisions of this act, other than for the purpose of giving evidence that the said person is a child, the committee or board shall record such observations stating the age of the child as nearly as may be and proceed with the inquiry under section 14 or section 36 as the case may be, without waiting for further confirmation of the age. Now, Lordship, second subpara is important. In case the committee or board has reasonable grounds for doubt regarding whether the person brought before it is a child or not, the committee or the board, as the case may be, shall undertake the process of age determination by seeking evidence by obtaining number one, Roman 1, the date of birth certificate from the school or the matriculation or equivalent certificate from the concerned examination board, if available, and in the absence thereof, number 2, birth certificate given by corporation or municipal authority or panchayat. Number 3 is important, very important, Lordship. And only in the absence of Roman 1 and Roman 2 above, age shall be determined by ossification test or any other latest medical age determination test conducted on the orders of the committee or the board. Now, Lordship, my humble submission is that if we consider if we consider the age of the victim on the basis of the school certificate, then the contents of that particular school certificate ought to have been proved as per Evidence Act, section 67 of Evidence Act.
By the maker of the document.
Yes, yes. By calling the principal of that particular school to prove that particular material object. Because Lordship, kindly
But
go.
was it your, did you pose any questions in your cross-examination?
Yes, Lordship.
To the effect that the girl was above 18 years?
Yes, sir. It is my presumption.
Look, you were in love with that girl.
Yes,
you
Lordship.
must be knowing her age. If you are in love with a girl and you made her pregnant, you, as a normal person,
yes, Lordship.
I'm quite sure you would be knowing the age of the girl.
Lordship,
What according to you is the age of the girl?
Lordship, at that point of time, I might have thought that she may be above 18.
You might have thought.
Yes.
You see, there's a question of thinking
Yes, Lordship.
and and understanding the real import of what you are doing.
Lordship.
You could make her pregnant, but you only think that she might be above 18. What is this? Is it logical?
Lordship,
You could bring another child into this world, and you're not sure about the age.
Lordship, yes, Lordship. I was also agreed to marry her.
That is a different issue. So you agreed to marry her.
Yes, Lordship.
And you wanted to marry her.
And I am.
And you're still willing to marry her. But what was the age of the girl at that time?
Yes, Lordship.
What?
So on that point, Lordship, my entire submission on that point, that the material object one ought to have been proved by calling the headmaster. then only age could have been confirmed.
How many, as per the evidence, is there anything from her side to show that you all were in a consensual relationship?
How many?
Was it a consensual relationship?
Yes, Lord.
Or was it one act or numerous acts? As per the evidence.
As per evidence, Lordship, in evidence also it is stated that 164 statement of the victim, she has stated that there is numerous times relationship between the victim and the accused.
Where is the 164 statement?
Lordship,
In the
164
appeal.
statement we have not filed with the appeal. I have available, Lordship.
LCR is here, it will be there, I can find it out. I can find it out. LCR dila hai?
164 to us.
Okay, we'll just
I'll
take a
take
break.
it up.
1 minute.
Break up, sir.
She's coming.
Yes.
So I got a 164 statement. It is in vernacular language, Lordship.
Yes.
It is in Assamese.
Yes.
May I have to read, Lordship?
You have to read and translate.
It is by 164 statement of victim. মোৰ নাম আৰু ঠিকনা ওপৰত দিয়া মতে সত্য ঘটনাৰ তাৰিখ মোৰ মনত নাই 2019 চনৰ অক্টোবৰ মাহত প্ৰথম ঘটনা হয় প্ৰথম ঘটনাৰ দিনটোত মোৰ ঘৰত কোনো নাছিল আৰু মই ভাত ৰান্ধি আছিলোঁ সেইদিনা দিগন্ত দাস আমাৰ ঘৰলৈ আহি মই ভাত ৰান্ধি থকা অৱস্থাত মোক পটিয়াই ধৰি বিছনা লৈ যায় আৰু মোৰ লগত সেক্সুৱেল ইণ্টাৰকোৰ্স কৰে এই সময় তেতিয়া ৰাতিপুৱা 11 বাজিছিল মোৰ মা পথাৰলৈ গৰু এৰাল দিবৰ বাবে গৈছিল আৰু দেউতা হাজিৰা কামত ওলাই গৈছিল তেওঁলোক ঘৰ আহি পোৱাৰ আগতে দিগন্ত দাস পলাই গুচি যায় আৰু যেহেতু দিগন্ত দাসৰ প্ৰতি মোৰ ভাল পোৱা আছিল I had love relations with the accused it is stated যেহেতু দিগন্ত দাসৰ প্ৰতি মোৰ ভাল পোৱা আছিল গতিকে ঘটনাৰ কথা মই মা দেউতাক পিছত জনোৱা নাছিলো I did not inform my parents regarding the incident
Lordship perhaps understand Assamese? Oh, achha. We have to translate them.
I have translated only main part Lordship ঘৰত কোনো নথকাৰ সুযোগত দিগন্ত দাসে মোৰ লগত প্ৰথম ঘটনা হোৱাৰ দিন ধৰি কন্টিনিউয়াছলি 6 দিন আমাৰ ঘৰলৈ আহি মোৰ লগত sexual intercourse কৰে
Continuously he has been doing for 6 days. He came
Doing what?
Doing sexual intercourse with her for 6 days.
For 6 days continuously from the day one.
He comes to my house and he does it.
Next line is Lordship. মই তাক ভাল পাওঁ যেহেতু as I love him সেয়েহে মই সকলো কথা সকলোৰে পৰা লুকুৱাই ৰাখিছিলো so I hide the facts from other persons as I love him দিগন্ত দাসে মোৰ লগত sexual intercourse কৰোতে মই তেওঁ কোনো ধৰণৰ বাধাও দিয়া নাছিলো when the accused
she did not stop him from
he stopped the accused during the sexual intercourse যোৱা নৱেম্বৰ মাহৰ পৰা মোৰ ঋতুস্ৰাৱ হোৱা নাছিল মই later is normal
she became pregnant thereafter
and later she became pregnant and she gave birth a girl child but she now the independent witness PW4 also stated in her evidence that Digonto Das that is the accused also agreed to marry her and he still agreed to marry her there are no any criminal intention on the part of the
But you see, only one problem is there.
yes Lordship.
He's a child.
Yes.
They're 14-year-old.
There is no consensual thing will come here. She is 14 years. And yes.
In fact, date of birth according to the school certificate is what?
Is 10/4/2006.
10/4/2006 and the FIR was filed on
FIR was filed on 23/4/20.
23/4/20.
20.
You see, so that means and by this time she was already pregnant. She had a kid also by this time. So that means everything happened when she was 13.
When she was 13, not even 14.
When she was 13, when she was not even 14. That's the problem.
Lordship, on that point, Lordship. So my only legal point is that the material object which is relied upon by the learned trial judge, it ought to have been proved as per the mandate of the Evidence Act to confirm her actual age.
That let us see in the main appeal. Let us see.
And that stage will come later because
now you see the problem is the fact of the case is that prima facie she is a child. At the time when you all had the sexual relationship,
yes,
she was less than 14. And even if she is 14, that is still a child in a way. You see, less than 16. And as per POCSO, it's 18. But earlier, if you remember, rape, that stringent provisions came into force if you are less than 16. So anyway.
Her statement is there, both 164 and this one.
So for the time being.
Lordship, my last submission is that during trial, the accused was enlarged on bail. During trial, he was very much enlarged on bail. And Lordship, now my out of the record submission is that there is nothing loss or nothing gain for anyone. If my appeal is ultimately failed, then he will have to go to jail for 20 years. So only, Lordship, for the time being, he may be enlarged because he is a laborer. By occupation, he is a laborer. He has his parents is senior citizen now. So, considering all the aspects, Lordship, if ultimately my appeal is failed, I will have to serve the jail term for 20 years. For 20 years, I will behind the bar. So only for this time, Lordship, He may be enlarged, and it is my out of record submission is there. The accused is also eagerly waiting to see her daughter. It is my out of record submission, Lordship.
But then it is in the evidence of the victim that he did not agree to marry her. He was called after the FIR was filed, but then he refused to marry her.
Okay.
That is in the evidence of the victim.
This
Now he says that he wants
appeal,
to
Lordship.
see his child. That's little unbelievable.
Anyway, we'll see. We'll see. Right now, I don't think this will be the right stage. Heard Mr. M. Pathak, learned counsel for the applicant. Also heard Ms. S. Jahan, learned additional PP. This application has been prayed for, suspending the sentence awarded to the applicant under Section 6 of the POCSO Act.
Yes.
By which the petitioner has been sentenced to undergo RI for a period of 20 years.
RI or SI?
SI for a period of 20 years.
Mm.
With a fine of rupees 30,000, in default SI for 6 months. The petitioner's counsel submits that the whose certificate submitted by the prosecution to prove that the age of the victim was around 14 years cannot be admissible in evidence, inasmuch as the maker of the said document, that is the principal of the school, has not given evidence proving the said age certificate of the victim. The applicant's counsel submits that in the statement given by the victim under Section 164 CRPC, the victim had clearly admitted to the fact that that the victim and the appellant were in a love relationship, and that she became pregnant because of it. He also submits that the applicant is still willing to marry a victim girl as on date. That's all. Anything else? That's all. Ms. S. Jahan, additional PP, on the other hand, submits that besides the certificate issued by the headmaster of Bidya Adarsha LP School, having clearly shown that the victim was 14 years at the time of the incident, the evidence of the doctor was to the effect that the victim was between 14 and 16 years of age at the time of the incident. She also submits that though the petitioner's counsel has stated that, applicant's counsel has stated that the applicant was willing to marry the victim, the fact remains that the appellant refused to marry the victim when
It was after the FIR was filed, he was called.
after the FIR was filed, And he was called by the court or by the police.
No, the family of the victim.
And he was
He
called
was
by
called
the
by
family of the
of
victim.
the victim.
Not before court. He has not.
Family of
denied
the
before.
victim. Family of the
Yes.
victim. Next. She accordingly submits that the application should be set aside, should be rejected. On hearing the counsels for the parties, we find that the question of whether the medical certificate, whether the age certificate issued by the principal of the school would be admissible as evidence can be decided at the time of hearing of the appeal. However, as on date, the age of the victim as had been accepted in terms of the school certificate would have to hold the field for the time. The applicant and the informant and the victim may have been in a love relationship, and a child born, and a child was also born out of the said relationship. However, the issue is not with regard to the consensual relationship between the victim and the applicant, in as much as the child cannot give her consent when she is underage and a minor. On considering the facts of this case, on considering the submissions made by the counsel for the parties, we are of the view that the application for suspension of the sentence and grant of bail cannot be allowed at this stage. First up, the application is accordingly rejected. The observations made in this order should not be taken as a finding made with regard to the appeal at the time of hearing the appeal. Sympathies are there, but what to do?
Certificate also, like there is not their case that any of the certificates mentioned under section 94 was there. So in the absence of those certificates, ossification. Proving the school certificate is not even provided under section 94. Proving the school certificate will come later. That will be, again, I'll submit it during hearing. 14, Your Lordship, this is an IA filed by the state of Assam. Now, what had happened is it is an IA filed in a disposed of criminal petition.
Now, let us see our prayer.
Lordship. Only extension.
I know, but let us see our prayer. Whether this application has become infructuous, that's my question.
This is what, of course, the listing became late. Yes.
So,
otherwise,
you
the time expired.
To allow some more time to verify and examine the documents placed. Now, this has been made on the basis of Annexure B, is it?
Yes, Annexure A, yes.
Annexure B.
2612 was the letter.
Now, where is this Annexure B?
Yes.
It's at the last page. Is it?
Yes, last page.
So
this is the one.
1 month's time.
1 month's time.
So now more than a month has gone by.
More than a month has gone by. Even filing was after the expiry of the
So
judgment.
It has become infructuous.
But then it was,
Now,
it
how?
was because the letter was before the expiry. Letter was issued on 26th of December and the judgment was of.
So you submit it now, you make it now, or how does it matter? Do we have to pass any order in this? What order can we pass?
Because in the judgment, it was strictly 1 month.
Okay, so, but, okay, now have you, you see, the thing is that.
Yes.
1 month.
30/11/22 was the judgment. So my 1 month expires on 30th of December. 26/12 this letter was issued. It reached our office. Thereafter, I had filed it. I had filed it next day itself.
So, but then now that period is gone.
That
so
it should have been within that 30th of
No,
December.
but then how does it matter if you do it now also? If it's already been done, how do you know? Might have been done.
Verification.
It's just to verify the document.
It's just to verify.
There is no penalty.
Only verification, any action within 1 month.
Correct, that's all. So how does it matter? No. Unless he files the contempt.
But yes, that of course contempt and all will not be there. Anything beyond 1 month, they cannot do anything. This
They
is what
can,
the
they
judgment. This is what the judgment says. The lordship will see the operative portion
No,
of
with
it.
liberty to state, to verify the document.
Yes.
So liberty has been given to you to verify the document.
Yes.
So if you do not want to utilize the liberty given, then what to do?
We want to kind of utilize the liberty, but 1 month was not sufficient.
Correct,
So,
but then now that your prayer is for how much time?
some more time. In the letter, it was 1 month.
Then?
In the letter, they said 1 month.
And what is the latest status as on today?
This is what I don't know, whether they have verified or not.
Then
let me take the instruction.
you take it, we'll take it up after 5 minutes. Just find out why should we keep it pending. It's such a small thing.
Lordship knows how these government people work. They'll also not know. This deputy secretary will not know. He'll again have to find out from someone else.
Correct. Heard Ms. S. Jahan, learned counsel for the applicant, who submits that in terms of the judgment and order dated 30/11/22, passed in criminal petition number 237/22, comma, the it was to verify the documents and the records brought before this court with regard to the with regard to Shri Amit Bose.
Nationality of his.
With regard to the nationality of Shri Amit Bose. Within 1 month. Next paragraph. The SP bracket B Karimganj thereafter wrote a letter dated 26/12/2020, praying that some more time should be asked for from this court for verifying the documents and records of Shri Amit Bose. In fact, the letter dated 26/12/2022 prayed for one more month's time for verification of documents. Next para. More than 1.5 months have passed since the letter dated 26/12/2022.
A letter is not 1 month, some more time.
It says 1 month, the
No,
last para.
instead of 1 month.
Acha. Okay, how much more time do you want? You don't know.
I'll take the instruction.
Okay, what do I say? Pustak. Ms. S. Jahan shall obtain instructions as to whether the matter has become infructuous
They might have done something.
or whether they need some more time to comply with the to verify the documents of Sri Amit Bose. So, sir, the specific, if some more time is required, comma, the specific number of days should be clarified by Ms. S. Jahan. Leave the matter on Friday.
Friday.
Yeah. Objection this one, okay?
This an application.
Has
for-
the LCR arrived?
LCR arrived
And I
and
think paper book is also, I see.
paper book is ready. It's reflected in the copy.
I have
Paper book
not
has been
received-
given to both of you?
Yeah, not given.
No,
That is-
even I've not got my
we have
paper.
not got the paper.
Paper book is there. And for the suspension of sentence, have you given
No,
your
I
objection?
mean, I'm told I've not filed my objection as of date. Somehow I missed that perhaps. Lordship will
So
give
what to
me
do?
1 more week's time.
Yes, let it be after 1 week then. Let her
1
file the
week.
objection, it can be taken up. next day.
Okay, right. In the IA, you're right. Ms. S. Jahan, additional PP is granted. How much time?
1 week time.
This is granted a week's time to file a written objection. List the matter after a week. Then in the main appeal, you write, as paper book is ready, copies of the same be furnished to the council for the parties.
It be after 1 week.
I'll list the matter after a week.
A week.
No one's ready. Ready?
Much obliged.
Return you back. Lordship, oblige Lordship. গমেই নাপালো উঠাটো নহয় দিয়া নাই ন মই just take one. নহয় কিবা হ'ল 15 টো আমাৰ চাও নাপায় তো হেৰিয়ে নাই কপি অফ দি নাই আমি কপি লোৱা নাই কিন্তু এক্সট্ৰাটো নাই আছে আছে এটা আছে হ্যাঁ আমি রচনা গম নাপাই নি না না মই ঘৰা দেখি দিছো তা মই কালি যেতিয়া
পেপার অর্ডারটো আছে সই করে দেব পেপার দিলো জি যদি
কত লাগে রোড
মাসি সমাতে আছে
ধুনীয়াকে পোৱা হ'লে কিজানি স্পেচ এতিয়া যি নহওক আকৌ বেঞ্চ চেঞ্জ হ'ব পাৰে এতিয়া কৰিবি আৰু নহয়
বাহিৰৰ পৰা ফোন কৰিলে ৰাখিছে কিন্তু মানে ইমানো মানে নাছিলে
হ'ব দে বেঞ্চ বদলক দে দে বাই ৰাকেশ এখন বেঞ্চ বদলা কিবা কথা আছে নি নাইতো